In this video, I will go over the rules you will need to learn grouped under the topic of trespass and the right to exclude. The law of trespass combines legal rules from torts, criminal law, other parts of the common law, modern civil rights law, and even the First Amendment to the Constitution. In class, we will discuss the cases you've been assigned to read to see those rules in action, and we will apply the rules to some hypothetical case problems. We will also continue to discuss some theoretical perspectives on the legal rules that protect all property rights, including the right to exclude others. Fundamentally, the right of a private landowner to exclude others from their land owes its existence to the state and the power of the state to enforce the right to exclude both in civil and criminal law. Likewise, the law determines what exceptions there are to the landowner's right to exclude others. We will first cover the basic elements of both the crime of trespass and the tort of trespass. Next, we will talk about what it means for an owner to consent and when consent can be improperly obtained. We will then discuss several limits in the law on the right of certain kinds of property owners to exclude others. And in a separate video, I will go over the remedies provided in the civil law to enforce the right to exclude. Trespass is an intentional tort. The basic elements are as follows. First, the defendant has physically entered on land, or an object owned by the defendant has physically entered on land. The entry is intentional. The entry is unprivileged, meaning not justified by necessity or public policy, and is without the consent of the owner. Trespass is also a crime in every state. For example, in New York, the definition is straightforward. A person is guilty of trespass when the person knowingly enters or remains unlawfully in or upon premises, and entering or remaining unlawfully is defined as an entry that is not privileged and is without the owner's consent. Now, when we talk about entry on land, we need to add an old common law principle referred to with the Latin phrase ad coelum ad inferos, which literally means up to heaven and down to hell, and simply stands for the idea that a landowner owns the airspace above their land and the ground underneath it. However, that absolute idea has been somewhat modified, and the right to exclude others from the air above your land and the ground beneath it has been limited by some modern developments. So, first of all, because of the development of commercial and passenger air flight, we now have regulations of the Federal Aviation Administration that limit the right of owners to exclude air flights above their land, and in particular, any air that is more than 500 feet above ground level is considered to be part of the public airspace. Landowners are therefore required to notify the FAA if they intend to build a structure exceeding 500 feet in height. This now raises some very interesting issues about whether overflying property underneath the FAA flight limit with drones, for example, constitutes a trespass. It is still the law that the landowner owns all the land beneath their property, including the mineral rights, unless they've sold those rights as part of a property rights transfer. One recent issue that has emerged in the process of fracking, which is extracting oil from shale deposits, is that as part of that process, wells that are dug on one parcel of land often extend underground under other landowners' property. And the question of whether those underground invasions constitute trespass is now being litigated in a number of state courts. As part of your reading, you will read a case involving the problem of when and how a landowner is considered to have consented to entry on their land, and when a purported trespasser has obtained that consent through fraud or deception. The basic idea is that consent is consent, even if it's obtained under false pretenses, but there are some limitations to that rule, as you will learn. It's also important to keep in mind that the ability of the police or any agent of the state to enter on private property without consent is significantly restrained by the Fourth Amendment's prohibition on unreasonable searches and seizures, a topic you will learn about more in criminal procedure. Another exception to the right to exclude is the principle of necessity. In an emergency, a person who is faced with loss of life or severe danger to persons is privileged to enter on private property. So, for example, when a landowner has a heart attack while mowing their lawn, the emergency medical technicians are not trespassing when they enter to rescue the victim, or even as Good Samaritans to go ahead and finish mowing his lawn. Another ancient principle of the common law is that certain landowners who have devoted their property to particular kinds of activities may not exclude members of the public from their property. And the category is generally known to be common carriers and innkeepers. So innkeepers, persons who provided lodging for a fee, and common carriers who provide transportation are required by this ancient doctrine to essentially take on all comers, assuming they're willing to pay the required charges and to not disrupt the activities of the business. In some states, the concept of common carriers and innkeepers has been expanded to other categories of public accommodations, but those states are very much in the minority. The ancient doctrine of common carriers and innkeepers has been expanded in a sense by the development of modern civil rights laws, and in particular, the passage of the 1964 Civil Rights Act. Part of the civil rights movement of the 1960s involved nonviolent protests and demonstrations to protest segregation, racial segregation, in certain kinds of private property. And in particular, students in Greensboro, North Carolina, and elsewhere engaged in sit-ins to protest segregation at public restaurants that were owned obviously by private individuals. And of course, every American school child learns about Rosa Parks and her nonviolent protest of segregation on the bus system of Montgomery, Alabama. Because of the part of the important origins of the civil rights movement included these efforts targeted at segregation not only in public facilities like schools and courthouses, but also in private property open to the public, the civil rights movement led to the enactment of Title II of the Civil Rights Act of 1964. That statute prohibits discrimination on the basis of race, color, national origin, or religion in certain kinds of public accommodations. Those public accommodations include hotels and motels, movie theaters, restaurants, and gas stations. And these particular categories, of course, were identified because they were the special targets of the struggle against segregation and racism and the inability of blacks to travel throughout the country freely. In the wake of the federal civil rights acts, many states have passed anti-discrimination laws as well, and many of those laws extend the category of private property owners who may not discriminate well beyond the limited categories in the federal statute. So, for example, the New York anti-discrimination law broadly prohibits discrimination in all sorts of retail establishments, specifically mentioning liquor stores, other retail stores, barbershops, and pretty much any facility that offers services to the public, including your future law firm. The Federal Civil Rights Act prohibits discrimination in the defined category of public accommodations on the basis of race, color, religion, or national origin. State laws, such as the New York law, often extend protection against discrimination in public accommodations based on other categories as well. So the New York law prohibits discrimination based on race, creed, color, national origin, sexual orientation, military status, sex, disability, or marital status as well. As a result, the ability of a private property owner to exclude others and to enforce that right to exclude with the law of trespass is limited by the principle that that exclusion cannot take the form of discrimination based on a prohibited category in a public accommodation. So in that sense, our constitutional principle of equality trumps the property right of landowners to exclude others. The other area in which constitutional rights have come into conflict with the property right to exclude is the right of free speech. However, under current constitutional doctrine, generally speaking, free speech is not a basis on which to justify a trespass. So leafleters, for example, who seek to spread their views generally may be arrested for trespass, despite the fact they might be exercising constitutionally protected activity. In a quick review of First Amendment law, we can begin with the Hague versus CIO case, in which the Supreme Court established the basic principle that there must be, in a public forum, access for speakers to express their views on public property, subject only to reasonable time, place, and manner restrictions. The public forum doctrine, which applied to state-owned property only, was extended in a very limited way in the Marsh versus Alabama case to certain kinds of private property that had all the features of state-owned property. That particular case involved a town in Alabama in which the entire town, including the courthouse, the schools, and all the other public facilities, were owned by a private company. And in that case, leafleters were found to have the constitutionally protected right to have access to that property. But in subsequent cases, the Supreme Court has decided that private shopping malls, which arguably served functions similar to the old company towns, are not public fora, and that individuals seeking to express their views do not have the right, without the owner's consent, to engage in First Amendment activity on private property. There are some cases based on state constitutions in which state First Amendment rights, or their equivalent, have been interpreted to protect peaceful leafleting on private university and college campuses and malls. That depends on state law. A final area of limitation on the right to exclude is found in various statutes that protect essentially the right of individuals to roam across the land of others. So we will learn in one case about the public trust doctrine that says everyone has access to the beach and therefore some limited right to cross privately owned land to reach the beach. Some states also have right to hunt or right to roam laws that limit the right to exclude people engaged in recreational activities.